10694, U.S. Bank National Association versus Ibanez.
Mr. Allensworth, good morning.
Good morning, Your Honor. May it please the Court, my name is Bruce Allensworth, and I appear today on behalf of the Appellants U.S. Bank as trustee and Wells Fargo Bank as trustee in these consolidated appeals. With me today is my colleagues Phoebe Winder and Rob Sparks, who are primarily responsible for the briefing of the case. We're here today before the Court on the issue of whether the present language of assignment that is contained in the respective securitization agreements were provided before the Court, provided to the land court below, can validly convey an interest in a mortgage in satisfaction of the statute of frauds.
Mr. Allensworth?
Yes, ma'am.
So you're not pursuing your initial arguments, that is, that the confirmatory assignment that was recorded was valid to show this, or, well, that's one. You're not pursuing that anymore.
I don't abandon the argument. I mean, I think of the issue of whether the confirmatory assignment considered in conjunction with the other indicia of ownership that were provided to the land court, which was the collateral file for both of these loans. The original
Even
note,
with
the original
even with the
mortgage.
assignment in blank in the collateral file?
The assignment in blank was in the
collateral file,
Was in
understand,
the collateral file.
And you're still arguing that that was sufficient to show a legitimate assignment?
We do argue that that is sufficient to confirm that there was an assignment of the court. That is not the assignment. The assignment of the mortgages in these cases were the assignments that appeared in the securitization agreements.
So with respect to the securitization, is it part of your argument that they, well, I guess I have two questions. One is, are you arguing that because there was, that your clients legitimately had the notes, that they had a right to the mortgage? So it was a potential as opposed to an actual assignment?
No, it was an actual assignment. They did have possession of the notes, their bearer notes.
Right.
And clearly under some views, at least the equitable title to the mortgage passes with the notes. And
But you're not relying on that? You're not relying on
I'm
that?
not relying on that, because if you look at the language of assignment that appears in the pooling and servicing agreement in LaRace and is referenced in the private placement memo, which describes the trust agreement in the Ibanez notes.
But you don't have, let's just take Ibanez. Those agreements are not actually in evidence, are they?
The pooling and servicing agreement in
But it's
LaRace,
referencing other documents. I'm talking about Ibanez right now.
That's correct. What we have in Ibanez now, well, what is a matter of record in Ibanez?
Record meaning record before the land court?
What we were able to produce before the land court within the time provided was the private placement memo that describes the language of the trust agreement. We actually have the trust agreement now, but we didn't have it at the time.
But the private placement agreement is really a description of what is going to happen, is it not?
Well, it is a description of what is in the trust agreement, and the private placement memorandum describes to the potential investors what the nature of the investment will be. But the trust agreement itself speaks in present terms, as is the case with the pooling and servicing agreement, which is part of the record in LaRace. The pooling and servicing agreement speaks in present terms of a transfer of not only the mortgage notes, but also all related documents, including the mortgage, and indicates in Section 2.01 of the pooling and servicing agreement and in 2.02 that is intended to be a present transfer of the note and related documents, including the mortgage.
So you're suggesting we need to look at, I think you said a few minutes ago that the assignment occurs in the securitization agreements.
That's
Is that what
correct.
you said? All right. And those agreements are between whom and whom?
The pooling and servicing agreement typically...
Is that different than the securitization agreement, or is that just one of the securitization agreements?
Well, it is one of the securitization agreements. Typically, it works as you'll have a mortgage loan purchase agreement, and then you'll have a pooling and servicing agreement between the seller or depositor and the trustee of the securitization.
And those are the securitization agreements that you're talking about?
Yes, I am.
All right, go ahead. Now, who are they between?
The mortgage loan purchasers agreements will be between the
Not
seller
will-
and the...
Not will be, in this case. Who
Yes,
were
they are between the pooling and servicing agreement in LaRace was between option 1 and Wells Fargo, and the pooling and servicing agreement and the trust agreement in Ibanez was with U.S. Bank.
Between option 1 and U.S. Bank?
Option 1, U.S. Bank as trustee.
And option 1, in fact, held either the mortgages or the specific assignments of mortgages?
That's correct.
Okay.
And that evidence was produced in the record below. And I note, at least as an evidentiary matter, for purposes of the land court's decision below, it really didn't contest the evidentiary quality of what was produced in terms of chain of title. What it was focusing on, excuse me.
No, go ahead. I'm just trying to leap ahead. And how does these agreements satisfy the statute of frauds, which I think is one place.
Well, they are a written memorandum that sets forth in writing the assignment from one entity to another of interest in notes and in mortgages.
So going back to the statutes of frauds, you agree, I trust, that a mortgage is a legal title,
I do.
and therefore that an assignment of a mortgage under the statute of frauds has to be in writing?
I do.
And do you also agree that that assignment in writing on the statute of frauds must be sufficiently precise as to identify the particular mortgage?
I do.
Okay, so did you provide, and I've tried to go through this, did you provide the land court judge with written documents identifying that there was an assignment of this particular mortgage, the Ibanez mortgage or the LaRace mortgage, and move it through the various assignments which led to the ultimate holder who went to foreclose?
We provided in the case of LaRace, there was a schedule of mortgage loans that identified the identity of the borrower was redacted, but the property description was in there. We did not have available to us.
That's a blank, that's what's referred to in some of the amicus briefs as a blank mortgage?
The blank mortgage is one of the documents that the pooling and servicing agreement provides will be transferred from the seller through the depositor to the trust. But that's, as the courts have described in Almeida and in Samuels, those are meant to be confirmatory assignments of the assignment that's already taken place, because it's very possible that these mortgages will pass through several hands before the holder of the note and the mortgage will ultimately have to realize on its securities. And that's why these things are assigned in blank. But they are confirmatory assignments of the assignment that's actually taken place.
But they're confirmatory only if there was an actual assignment that it's confirming.
Right.
Assignment from the actual mortgagee.
Assignment from, say, option 1.
That's correct.
And you say there is a document from option 1 to the holder of the mortgage that says option 1 assigns mortgage, a particular identifiable mortgage?
Yes. Here's what I'm saying.
Which page of the record? I couldn't find it. Which page of the record are you saying it's there? I mean, the land court judge essentially is saying, show me you're the holder.
That's correct.
And
we did that, I would suggest to you, 2 ways.
But in option 1 as holder, not as servicing agent.
Well, the actual holder would be the trust. The trust would be the holder.
The assignment's
of
got to
the
come, you
mortgage.
said it came from option one.
From option one, I'm sorry, that's correct. They were the ones who transferred into the trust.
In what capacity? In what capacity?
As sellers. I mean, they're selling the mortgages into the...
So in answer to Justice Gantz,
Yes.
the land court judge saying, "Show me, you're the holder," you said we did that in two ways. Which are the two ways?
Well, there were two ways. First, in terms of LaRace, there was a mortgage loan schedule that was obtained off Bloomberg that had the LaRace name was redacted for privacy reasons. But
And that's attached to the securitization agreements?
That was, I'm not sure that was attached. I don't believe those are attached to the securitization agreements.
They're schedules to what, then?
They are schedules to the agreement.
Okay, that's what I
Yes,
meant, schedules
I'm
to
sorry.
the agreement.
What we did not have at the time, although I represent to you we do now, was the trust agreement with the schedule of loans. So what we also produced to the land court, and actually what it still has in its possession, is the collateral file for the loans, which include the original note endorsed, the original mortgage, and the original assignment.
But isn't the original assignment one in blank?
Yes, the original assignment in blank.
So that doesn't, what you just said, that doesn't satisfy the statute of frauds.
Right. The assignment in blank itself is the confirmatory assignment. Where the assignment actually takes place is in the language of the pooling and servicing agreement or the trust agreement, which affects the present assignment of the note and the mortgage into the trust. And that appears, for example, in the race at section 2.01 and 2.02 of the pooling and servicing agreement.
These are documents which you say you presented to the trial, to the land court judge, or documents which you did not present but now say you found?
In the LaRace case, the pooling and servicing agreement is in the record, as is this schedule that was obtained off of Bloomberg. What is also in the record in terms of Ibanez is the private placement memo, which has the language of the trust agreement in it. In addition, we produced the collateral files that have the original documents that were transferred. So
I have a question for you, counsel. I'm reading from the land court's judge's memorandum. He says, I want to know if you disagree with any of these things. He says, option one executed an assignment of the mortgage in blank, that is, without a specified assignee, hereafter the blank mortgage assignments. These blank mortgage assignments were never recorded and they were not legally recordable. You agree with that?
I'm not sure that I
I'm
agree
reading
with that.
from
I do agree
page 12 of his memorandum.
Right. I do agree that he focused on the assignment in blanks more rather than on the actual assignment language of the pooling and servicing agreement. But
Well, in fairness, at the time he wrote that, he didn't you hadn't mentioned the pooling and service agreements, had you?
yes, we had. They were in the record. And he had
At the first decision?
He had not in the first decision. In the first decision, basically what they were relying on was REBA Title Standard 58, which said you could, obtain the assignment.
He went on to say, since the blank mortgage assignments failed to name an assignee, they were ineffective to transfer any interest in the mortgage. And he cited to Flavin versus Morrissey, one of our cases. Are you acquainted with that case?
I am acquainted with Flavin. But what I'm saying about the assignment of mortgage in blank, and I think this is what the federal courts have said in Ray Samuels and in the Brubagiano case, is that the pooling and servicing agreements themselves are the documents that affect the transfer of sale. The assignments in blank, which may be filled out later, are confirmatory assignments, which confirm that which has already taken place, which is the transfer that is affected under the pooling and servicing agreement in LaRace and the trust agreement in the Ibanez case.
But the pooling and service agreement in LaRace was between Asset-Backed Funding Corporation and Wells Fargo, correct?
As trustee, and Wells Fargo is the trustee of the trust.
But where is the document that indicates how Asset-Backed Funding Corporation had this mortgage assigned to it from option one?
That's in the pooling and servicing agreement. It passes through the depositor, which is asset-backed, into the trust.
Are you saying option 1 is a signatory to the pooling and servicing agreement?
I believe it is, Your Honor. Yes, and they're signatory in the mortgage loan purchase agreement as well.
Which you gave an unsigned, there's an unsigned text as part of the PSA that's given, but not the agreement itself was given.
Right, those agreements were were obtained off of the Edgar site from SEC, so they were the unsigned versions filed with the SEC. We have the signed versions, but at the time, those were the unsigned versions from the SEC.
Thank you, Mr. Allensworth.
Thank you, Your Honor.
Good morning, Mr. Collier.
Good morning, Your Honor, and Your Honors. Being very straightforward, that was what you just heard is not true. That is, the purchase and servicing agreement in LaRosse says that the mortgages are being assigned by the asset-backed funding corporation. There is no assignment of the LaRosse mortgage anywhere in the world from its originator, option 1, to the asset-backed funding corporation. The private memorandum in Ibanez is even more ludicrous because the private placement memorandum, Your Honors, is an advertisement. They put it on the net to persuade people to buy their paper, which I'm refraining from characterizing in a surfeit of caution. That document states that Lehman Brothers Holding, through the Securitized Asset Securities Corporation, assigns the mortgages. There is nowhere in the world an assignment of the Ibanez mortgage to either the Securitized Asset Securities Corporation Mortgage Pass-Through Certificate Series 2000Z or the Lehman Brothers Holding Incorporated.
Other than the one in blank?
Your Honors, we've, I believe, agreed that an assignment in blank conveys nothing.
I know, but I'm just saying evidence of an assignment. There's evidence of an assignment.
There's evidence of an assignment in blank to no one, right?
Right,
There's
but
no one
that's
named
the
in an
only
assignment
evidence.
in blank.
But it's from option 1.
In the LaRace case, there is an assignment from option 1 in blank. In the Ibanez case, again, the record is worse because there's an assignment out of Rose Mortgage, which was the originator of the Ibanez mortgage. In blank. Your Honor, respectfully, the assignment out of Rose is in blank, and then sometime later someone stamps it with option 1. And this court has held, and the District Court of Massachusetts has recently held, as the bankruptcy court has later held, that stamping the grantee on post-execution renders the entire assignment void because it's a material alteration of an assignment.
Without getting into the bankruptcy cases, and I'm not asking you to defend or not, but I am asking you to help me. The Real Estate Bar Association, and that's a good chunk of lawyers in this Commonwealth, and they do this all the time, they say, you know, this is the land court's decision is completely unanticipated. Essentially, the sky will fall.
Your Honor, for 200 years, this court has been invalidating foreclosure sales where the mortgagee was not accurately or properly identified. And the one thing that's undisputed here is that neither the Securitized Asset Securities Corporation Mortgage Pass-Through Certificate Series 2006Z nor the AFBC Asset-Based Securities Series 2005 Opt-1 Trust held any assignment from the originator or from the subsequent acquirer of these mortgages at the time they conducted the foreclosure sale.
When you say that, do you mean that they had no recorded assignment or they had no assignment in fact?
They had no assignment at all, Your Honor.
They had no written assignment.
They
They had no written assignment, which I understood that to be what we were talking about. I thought we had agreed at least that an assignment must be in writing and must reasonably identify the property being conveyed.
Well, surely in order to be recorded. But let me ask you this: who could have brought this foreclosure action? Surely a foreclosure action could have been brought under the mortgage. Who could have brought it?
The originating lender, if no subsequent assignment had
And
ever
so the
been
originating
valid.
lender brings it, and the evidence is actually you agreed to assign this to someone else.
A future agreement to assign something,
Or you
which they
assigned.
have not yet done. They had not.
So the
yet executed
originating lender still has, even though they have assigned this right and the note is gone, they have none of that. They still could bring this foreclosure action?
They have legal title and can therefore do so, and this court has held that.
How do
Sorry,
they have legal title if the note's gone? For fair consideration, too, by the way. Wasn't just
Because,
stolen.
Your Honor, as early as 1820, this court has held that the holder of the note and the holder of the mortgage can be different entities, and that only the holder of the mortgage can conduct a foreclosure sale. There's a couple of cases starting in the 1850s, and there's cases going all the way up until now that repeat that holding. That is, that the holder of the note possesses the right to the debt, and the holder of the mortgage possesses legal title and the right to foreclose. And, Your Honors, that's not just this court's common law.
And the holder of the note has an equitable right to the assignment of the
Against
mortgage.
the holder of the mortgage to acquire it in equity if they can prove equitable title.
They don't have to acquire it, they can order it that it be assigned to them.
That's right. If they can prove
no
equitable
consideration.
title, they can acquire the mortgage.
But if they
And
haven't done that, is your point, then you're stuck
no
with
one
the
ever
whole-
did.
Right.
As of today, no one has ever brought an action to acquire equitable title to these to these mortgages.
If I can go back to the Chief's question, I understand the principle that a holder of a mortgage has to be the holder of the mortgage, and it has to be so by a written assignment. And if you're right, given the extraordinary sloppiness that accompanied the securitization of mortgages, there could be hundreds of thousands of these, maybe more, of these mortgages which turn out not to be true mortgages. What do we do about not so much the banks which purchase them at foreclosure sale, but the individual who then purchases the property from the bank and now is moved into a previously foreclosed home, believing that they now have fair and full title to their new home? What do we do about them?
Well, Your Honor,
Purchaser in good faith?
it may be that in some cases they're going to qualify as a bona fide purchaser for value, even where they're not, Your Honor. As we know, Ibanez is a year and a half old, and there have been numerous ways that the industry has worked to develop this, including getting the former owners to execute deeds in terms for some or all compensation, bringing actions against the banks and the title insurers in order to recover for the lost title to the property. That is, since T.J. Hooper, Your Honor, places where an entire industry has been negligent or reckless have arisen. And if you've been paying any attention to the media in the past 2 years, this industry was insane in its underwriting practices and in its foreclosure practices. There are indeed industry costs to that, which this industry properly bears. The former homeowners shouldn't be paying that cost, and there is indeed an entire allocation of liability issue here that the market is taking care of.
Well, equitably, sir. I mean, you're sort of placing blame on lots of other people, but equitably, your clients didn't pay the note, and they should properly have had their homes foreclosed on. Your argument is, well, it should have been someone else, not this person.
My argument is that they had a lawful right under the contract they assigned to have only the lender or the holder of a written assignment from that lender accelerate the note and foreclose, and that entity didn't do it.
Could I just ask you one question? Because I know your time is up. But are you agreeing with the plaintiffs that, not on the facts of this case, but as a theoretical or legal matter, if the securitization agreements demonstrated the necessary assignments, that would be enough, even though nothing had been recorded or was in necessarily recordable form?
No. The securitization documents are not assignments, Your Honor. They're contracts between the depositors, the trust, and the investors as to what's going to be done with the piece of property. They don't actually, or at least none of the ones I've seen, and the ones that exist here are among them, adequately describe the property that's involved. They don't adequately bring the chain of title from the original lender to the depositor or the assignee of the depositor. And that's the Samuels case, Your Honor, if you, without over...
Yeah, no, I understand that, but that's really a sort of factual matter. I mean, you're not, I guess this is, just cut to it. You're not saying, are you, that yes, you need to have either a recorded or a assignment, or an assignment that exists somewhere in paper that is in recordable form at the time of the foreclosure?
I would answer that with two things, Your Honor. You have to have an assignment that's intended to operate as an assignment.
Fair
and
enough.
These trust documents and these PSAs do not.
Okay.
And they explicitly say they do not. In fact, they explicitly say that you've got to have a real assignment of the
Right,
property.
I understand that.
But the second thing, Your Honor, and, you know, I may as well go there, if this Court's actually thinking about how any alterations in the law that ought to happen as a result of this case, this Court should amend the common law doctrine that assignments don't have to be recorded and indicate that as to foreclosure sales, the chain of title must be recorded intact prior to the foreclosure sale. Because if we're going to have any certainty in a world in which no one has the slightest idea anymore who has a valid legal right to ownership of a mortgage, and if we're going to create any legitimate title in people purchasing at foreclosure sales, then the common law rule that says you have to have an assignment in writing but it doesn't have to be recorded should be modified to reflect what I can call nothing but the current madness in this industry.
I suspect, Mr. Collier, that wasn't a response to Justice Botsford's question.
It was not, Judge. And for that, I apologize, Your Honor.
And with respect to confirmatory assignments, which have been recognized as the way in which an otherwise perhaps unperfected assignment is perfected, or an intended assignment is perfected for recording purposes, that has no value.
A confirmatory assignment can only confirm
The
a
intentions of the
prior
parties.
assignment that was flawed. There's no prior assignment that was flawed here. There's no assignment at all.
I thought you said there is an assignment that's flawed.
There are assignments in blank which are void.
Oh, okay.
They're not flawed.
They're void.
They're void. They have no legal efficacy at all, and they're not to the grantee. That is, no one, at the time Option 1 executed the assignment in blank in this case, Option 1 didn't intend to assign that property to the secured asset-based trust 2000. That deal had never even been contemplated at the time. They intended to do just what they did, which is assign the property to nobody. And in this Commonwealth, you can't do it.
Thank you.
Sorry, Jim.
Mr. Lasso, good morning.
Good morning, Your Honors. Mr. Collier, there is some redundancy, and I'll try to keep that at a minimum. Kind of changed my argument, but the first thing I guess I would like to address is that from what we've heard today, that it's given that the securitization agreements are in the record. They were never produced until the motion to default for default judgment. And on that basis, on a clearly erroneous basis, and in my particular instance, Wells Fargo stated that under 60B1, 4, and 6, that they should have the right to introduce these documents. And under 4 and 6, there was absolutely no evidence provided whatsoever outside of their bald assertions that they should be allowed under that basis. Under 60B1, they said surprise, and the record appendix clearly shows at page 5 that Wells Fargo was clearly advised by the land court to prepare memorandum or brief the issue as to the application of 244-14 and the holder status.
Mr. Russell, well, do you, I mean, before you even get there, though, do you agree with, I think it was Mr. Collier, who said that even with what got filed, you would say late and shouldn't be considered, but even taking what was filed, that there is no indication of an assignment from option 1 to asset-based, whatever the name is?
That is correct, Your Honor. I didn't want to jump back into the securitization, but yes, that's true. One thing my brother Collier did not discuss, he did tangentially, but Wells Fargo is also stating that there's a confirmatory assignment. The assignment in evidence actually states that it's from option 1 to the trust. Looking at the agreements, there are 4 parties to that agreement. There is the originator, which is option 1. There is the seller, which is Bank of America. There is the depositor, which is Asset-Backed Funding Corporation. And then there's the trust. Additionally, Wells Fargo's appellant brief stated, quote, "The plain meaning of the securitization agreements clearly states that the assignment happened from option 1 to the trust." The plain meaning of the document clearly states that only the entity known as the depositor can put the loan into the trust, and there's a reason for that. Also, the plain meaning of the document clearly states that all of these assets have to be in that trust by October 31st, 2005. The assignment that we have in evidence from option 1 to the trust clearly states that it happened in, I believe it's May or April of 2008. However, the distinction between the Laray's case and the Ibanez case is there's an effective date that was placed upon this assignment of mortgage that appellants are now relying on, and it's April of 2007. Taking that into consideration, that is still about 18 months after the closing date specifically recited in the pooling and servicing agreement and registration documents. And these are not dates that are just arbitrarily selected. On the closing date...
Is this the confirmatory assignment you're talking about?
That is correct, Your Honor.
All right. Well, they obviously happen, but they always happen after the fact, or frequently happen after the fact. That's why they're called confirmatory.
However, if there's no evidence of that, Your Honor, there's a blank assignment. We don't know where that went.
Well, obviously the parties intended the assignment to move up the chain. Your argument is, well, they may have intended it, but they did it defectively. But a confirmatory assignment presumably confirms the intentions of the parties, which were that the assignment would move up the chain and into the pool.
Correct, but under the pooling and servicing clear agreement, there's a steel door that closes on the closing date under what's called a real estate mortgage investment conduit tax provision. No assets can be added to that trust, and it's clearly in the record, and I believe I cited to it in my brief.
Mr. Russell, let me ask you this. Now we're off into what should the law be. Never mind if it's prospective or not prospective, but we are a common law court. The real estate bar, in addition, Bar Association, in addition to asking that whatever we do, they would like to affirm Judge Long, but prospectively, but they also, and I'm just quoting, that the court provide guidance as to whether it is sufficient that for a foreclosing mortgagee holds a fully executed recordable assignment to qualify as a mortgagee for purposes of exercising the statutory power of sale under 183.21 or 244.14. What's your view on that? I mean, assuming that we can give meaning to fully executed, don't know quite what that means. I mean, blank mortgage, don't know. Recordable assignment, I take it recordable assignment must mean the property has to be very specific. It's in the chain of title. So what's your view about that?
Well, from my understanding, recordable form would be governed by 183.6c. And I think I pointed out in my brief, I believe I did. If I didn't, I apologize, that there's an internal consistency which states that, if the name and address of the assignee have to be on that assignment of mortgage. So, yes, I believe that that has to be at least executed. I think there has to be a fully executed.
They say executed, fully executed, recordable assignment to qualify as a mortgagee.
Yeah, recordable, Your Honor, I mean as in to be able to be recorded or actually?
No, I take to be recorded, so I'm not addressing Mr. Collier's point.
Okay, I apologize.
No, but you may say, no, if you're going to do anything, make it recorded, but let's assume.
I think Judge Long stated it best. I believe that best practice that it would be actually recorded as to show evidence on the Registry of Deeds.
How many states do that? I mean, I know our law is a little different, so.
I
Okay.
don't know, Your Honor, unfortunately.
Can I ask you, why hasn't your client essentially waived any challenge to the defects in the assignments? I mean, your client didn't challenge the foreclosure.
Well, there was never actually a default entered against my client. It's not in the record. They were never defaulted.
The property was foreclosed on. Let me understand that again. Property was foreclosed on. Your client didn't challenge the foreclosure. This all arose in an effort to clear title sometime later, but
Correct.
Never challenged the foreclosure. Never said, no, Mr. Bank, you didn't have a proper assignment. You didn't get it in a proper written form. So, and with a confirmatory assignment, why do we need to decide this issue? Why isn't this a waived issue?
Well, my view would be that the appellants didn't raise that issue. They didn't raise it, the securitization agreement in any of these, their action. They just basically said that they were going to take this, and you're correct. They did not.
Well, certainly your clients received notice of the foreclosure, and they had an opportunity to challenge the foreclosure. They could have filed a suit challenging the foreclosure, saying, oh, no, we didn't borrow the money from this bank.
Correct.
We borrowed money from some other bank. That didn't happen.
Correct. But
And then there was a foreclosure, and then sometime later, a year and a half, there's an effort to clear title, and that's when this all comes up.
Correct. But the condition preceding is that the mortgagee is actually the person entitled to bring that action.
And that can't be waived or fixed by a confirmatory assignment or anything of that sort?
Not if it's not the right party.